Anybody hearing me?
Yes, I'm hearing it.
Yes, we can hear you.
Great. So we have persons slowly trickling into the session. So we will give them about another 5 minutes to enter, and then we will officially commence at that time. So we will be commencing in the next 5 minutes officially. Thank you. Good morning again, everyone. So for those that are just joining us, let me say thank you. Good afternoon. Let me say thank you for being here once more again for the second day of this lecture session. Before we continue, let us just have a moment of gratitude. To our Heavenly Father, I just want to say thank you. Thank you for another day. Thank you for another opportunity as we are gathered here in such a fashion to impact lives. I do ask and crave that you will let this session be fruitful and beneficial to someone so that they can implement accordingly and know that cybersecurity it's not just a technical thing for technical people, but for everybody that is using a specific space. I pray that you continue to inspire the presenter. Whatever I feel of asking, I pray that you fail not to grant it unto us. Amen. So for those who were here yesterday, you know that the session was led by our Colonel Sterling. The session will also be led by Colonel Sterling today. However, the topic of discussion will be the privacy versus the security dilemma. We did the introductions yesterday, so I don't need to go back into those or into that introduction today. And with no further delay, I call our Colonel Sterling to the floor. Colonel Sterling.
Good afternoon, all, and welcome to the second in the series of webinars for the National Cybersecurity Awareness Month 2021. The moderator has already spoken to yesterday, and I must apologize myself for the premature way in which the session ended. As a consequence, I'm going to try to speed through a little bit more today. We have just about an hour to get through the session, and I want to have some sort of interaction at the end of my talk, which will sort of be used to gauge the response and the knowledge base out there as far as the security and privacy discussion is going. Now, we in Jamaica would have looked at this dichotomy, and we would have drafted, promulgated, and is in the process of operationalizing the Data Protection Act of 2020. And that is only sought to deepen the conversation as it relates to security and privacy. I believe we are really set up to have a very rich discussion around this topic within the next 2 years, as the two main players within the obligations of that piece of legislation, the data controller and the data subject, jockey for how it actually plays out in reality. Now, as far as maturity of this discussion, the European Union really sort of leads the way, and the GDPR is probably the landmark piece of legislation that everyone's seeking to regularize and provide a legal framework within which the conversation can take place, references their statutes and how they actually implement it. locally, the conversation has taken many twists in the last year, year and a half, primarily with the foray into the virtual space by a lot of the persons and how they approach commerce, socialization, and learning. The questions that we have to ask, therefore, are really, if there is no substantive law in the physical space, can we bring about a legal requirement in the virtual space? And I ask you to cast your mind back to a story that had some publicity to it, where a young man was seen on a video in a virtual setting, making derogatory remarks with respect to the Honorable Prime Minister. And the discussion that followed that asked some very pointed questions. Was it that the man was actually in a public space? Is cyberspace now considered contiguous to our personal space, or is it a public space? And so, as we delve into the topic today, I want us to really give a thought to the many stories out there as we progress, and hopefully at the end of my formal discourse, we will have a rich discussion. So what I intend to cover today actually seeks to look at a few terms that I need to define in order to really set the stage for the discourse. Then we're going to look at the principles of data privacy, the principles of data security. I'll summarize and we will have a discussion. So when we talk about privacy, we're really talking about that inherent right of an individual to have control over how personal information is collected and used. And this is a definition that I took from emotive.com, because the way in which data privacy is really defined sometimes has cultural connotations to it. And so I stayed away from nationally defined precepts. Data security, as defined by IBM, is a practice of protecting digital information from unauthorized access, corruption, or theft throughout its entire life cycle. Inalienable right is defined by the legal dictionary as personal rights held by an individual which are not bestowed by law, custom, or belief, and which cannot be taken away or given or transferred to another person. Responsible behavior is really about doing what we do in cyberspace with due regard for the other persons who utilize the common space. Now, it was really a challenge to find a definition from any source that really works, because the discourse out there is really very young, and it does not seek to come down on any side of the fence, whether it is that we need to look at this, the nation state as far as responsible behavior in cyberspace, or we need to look to the individual. And so what the UN seeks to do is to affirm the applicability of international law and the adherence to voluntary norms of responsible behavior as exists among and between individuals and nation states utilizing cyberspace. So when we take that and we look at how the whole conversation unfolds, we're looking at the principles of data privacy, which are really lawfulness, fairness, and transparency, a limitation on the purposes of collection and the processing and storage of that data, data minimization, the accuracy of the data that is collected, the data storage limits, and integrity and confidentiality. Now, if we delve a little deeper into all of these, what we find is that the concept of lawfulness really seeks to ensure that there is a legal framework that allows for the collection of data. If you think back to the start of the pandemic, you would realize that you normally walk into a banking hall and the security guard just ensures that you're not robbing the place. But now when you do so, they're telling you to remove your mask and look at a camera. The questions that really we should be asking is, what happens to this image that you capture? How long do you keep it? Do you share it with third parties? Are you legally allowed to really capture my image like this? And so the bigger question is CCTV coverage of common spaces legal? But we'll get back to that later on. There is a presumption within the concept of lawfulness of data collection as far as data privacy is concerned, that the data subject consents to that data being collected. That by virtue of collecting the data collector is really getting into a contractual arrangement with the data subject that is now provided within the legal aspects of, in the case of Jamaica, the Data Protection Act. That contract really now puts on the data collector a legal obligation to ensure that the data as is collected is used for the purpose posited for the collection. The vital interest of the data subject must also be taken into consideration, and the legitimate interest of the data collector must be considered. So when we talk about lawfulness, whatever the jurisdiction, there needs to be a piece of legislation or pieces of legislation that actually legalize the collection of this data. In the same breath, here in Jamaica, we go to a lot of places of business, and the data that they're requesting to do certain basic transactions really are not commensurate with the nature of those transactions. And so the second concept is the one of fairness, which really it permeates through the DPA 2020 and assumes that your data is being collected in good faith, will be stored to the best of the ability of the data controller in good faith, and will be utilized by that data controller also in good faith. So it ought not to be that you go to an institution to do transaction X, and by the end of the day, your phone or other device is being inundated with telemarketers. That really breaches the good faith concept behind data collection. Then we have transparency. And here we're really looking at the fact that the data controller must take into consideration that it is not only lawful to be collecting the data they're asking of the data subject, but they really have a need for it. And if they have a need for it, then the categories of data to be collected must really be based on the minimalizing principle. And the lawful basis must also be one that can stand up to the interrogation of any person that is so subject. The intended use of the data. So if you're collecting the data to process a loan, you ought not then to use the data to promote your other products. And the shelf life. Now, we would have seen in the media, the now famous or infamous No Movement Day party. And last evening while journeying home, it was a very comical repartee by the host of of a talk show, essentially, or a news review program that sought to chronicle how the video footage of the event was requested by the JaCIRT and the fact that given the elapsed time, that footage may no longer be available. And so the shelf life of the data that is being collected is something that is really critical for us to consider when we are approached, especially when it's personally identifiable information. The collector of the data also has an obligation to divulge third-party interests. So if a credit union collects your data and they're going to then push it off to a marketing company, that must be made public. And as individuals, we really need to become more aware of what they're asking us for and why they need it, whether they're justified in asking for it, or the transaction we're doing does not warrant them collecting it. And finally, within these principles, we're looking at the jurisdiction. So when we look, for example, at many of our bigger banks, they're subsidiaries of multinationals. When they collect your data, does it reside only here in Jamaica? Or does it go to a third-party country? And what are the laws that govern your data once it gets there? Whether it is being stored, whether it is being processed, or whether it's just in transit. And so we have to ensure that data collectors step up to that transparency requirement. And certainly, once the time frame for operationalization of the DPA 2020 is expired and the requirements become enforceable, these are things that we really need to ask as individuals and corporations whenever we're treating with giving out information. So the limitations on the purpose for which the data is collected, I have alluded to, but really it seeks to take into consideration all of that requirement for the fair processing of your data. Now, when we look at how we treat data here in Jamaica, it is very, I think haphazard may be a very strong term, but it varies from corporation to corporation. It varies from purpose to purpose. And so we must ensure that when the data is being collected, that the processing that it goes through ought to be what it is. So you go to open a loan facility and they collect your data. Is it okay for them to run it through what they call them now, credit bureaus? And these credit bureaus, how do they get your data in the first place? Do you say to an institution that you may have gone to, it is okay to share my information with credit bureau X, but not credit bureau Y? Is there a legal basis for how this happens? And so that fairness in collection, processing, and storage must be per the disclosure that is there. Now, a lot of the organizations will say, well, it was in the fine print. And a lot of us as data subjects do not read the fine print. But in this age where information is your treasure, you must start taking the time. It doesn't matter if the line behind you is a mile long or the customer service representative attending to you is a bit impatient. If you have a need to, read the fine print. And if it means suspending the transaction you're doing in order to understand the fine print, then you do so. What I have found from experience, and certainly some of you may have as well, is that a lot of the customer service representatives cannot explain the fine print on the documents that they're giving to you. But they're asking you for all this information that you're really unsure how it is going to be collected and what purposes they're going to disclose it for. And so it comes then to your expectation as a data subject. when this data is collected, what do you expect to happen to it? So if any of you were to just simply take up your device and Google yourself, are you comfortable with what will pop up? Or will there be surprises? And this is something that comes sometimes out of what we do inadvertently, or what data controllers, data collectors do with the data that we give them. But we will get back to that point later on. The concept of data minimization says very simply, if you don't need it, don't collect it. So when we go to transact our business and we're being asked for all manner of personally identifiable information, if it seems too onerous based on what we're doing, we probably should just take a step back and ask the question, why is all of this needed? And it doesn't matter how pressed for time we are, or some of the lofty idealistic responses that we will get. Ask to read the fine print, ask for the justification. And at this stage in our evolution of data privacy discussions, really take the time out to familiarize yourself with some of the obligations and provisions under the DPA 2020. But for the corporations here represented, if you've collected the data and it is no longer required, you have an obligation to destroy it. Now, how many of us have gone onto a social media platform, started to open an account, forget it, click cancel, disappear, and then come back sometime after, try to start a new one, and something pops up and says, do you want to use the data you previously entered, or do you want to create a new account? Some of us have experienced that. And that is because whichever platform it was did not exercise that or did not live up to that responsibility to destroy the data if it was not needed. And so we have to ensure that social media blunders do not come back to haunt us later on by, if we're unsure where the data we've entered has gone, to write to the customer service department of the institution or facility and inquire where that data is. As data subjects, we have a further obligation to ensure that the data collected on us is correct, it is accurate. By so doing, we help to safeguard the integrity of the data that is collected upon us. Now, when you think about it, if the data is incorrect, let's say the spelling of your name or your address, and you allow it to be captured and stored, probably processed, and the organization is such that that level of verification did not catch it, and at a later date you try to do something else, and you're relying on that data that was previously captured, you're going to have challenges. You, as the data subject, have a right to have any errors with respect to data captured on you rectified. That rectification can take many different processes. And the ease with which it is done is going to be determined essentially by the nature of the relationship or the posture of the data collector. Additionally, if you no longer have a need to use the facility, you have the right to have that data erased. We've seen, certainly in the European jurisdiction, and within this region in Brazil, significant landmark cases where persons have fought the pink, if you wish, the system, to have their data scrubbed from databases. Now, in the context of a national registration system, we have to be even more vigilant about how what is collected is used and how it is destroyed. So the life cycle of data does not just stop with your cessation of a relationship with that data collector. It ought to stop with the destruction or anonymization of that data. When data is collected, it is no longer good enough for us as individuals or even corporations to accept that the data will be stored indefinitely. Especially if this data is personally identifiable data. There must be a time limit on the data, whether it is the time limit of the facility you're accessing, or there is a statutory limit. But no longer should it be acceptable by anyone to be told that we're collecting your data, but we will keep it indefinitely. And if in the interim or anywhere before the expressed shelf life of that collected data, you have a need to sever ties, there needs to be that erasure or anonymization. When the DPA is fully operationalized, I hope, similar to the GDPR, we can actually say to an entity, what is your data retention policy? And by law, they ought to be required to show it to us. While the law says it should, the regulations are not yet promulgated. So how this will actually happen, we're not yet sure. However, this data retention policy should be fair. So if I am accessing a facility with you, and I'm picking on the financial sector here because they are probably the biggest culprits. If my facility with you will last for 10 years, I should not turn up 11 years after and you still have my data. That is the essence of what I'm saying. And when I ask for your data retention policy, you shouldn't have to go and search for it. It should be publicly available. And the commitments to storage, to secure storage, should be something that is clearly listed in this policy. Additionally, if that period of retention is done, I should be able to ask you for proof of erasure. At this stage, anonymization is not good enough. I would like to be forgotten from your database. You should be able to prove to me that this is the case. And so, given the similarities with the provisions in the Data Protection Act of 2020 and the GDPR, this is something I hope will actually be fleshed out in the regulations and not just be left in a vague and complicated legal statement in the Act itself. Now, as far as integrity and confidentiality of the data that is collected on you, there has to be an implementation of protection by either design or default. And this protection must have certain basic standards that it adheres to in terms of encryption, pseudonymization, to ensure that the confidentiality, integrity, availability, and I am throwing in here, resilience of the data is preserved. If there is a breach or a corruption of that storage, the process of restoration ought to bring your data back to a state that is commensurate with what it was before the breach or the corruption took place. and the data collector / controller has a duty to ensure that measures are put in place to ensure the security of the data that is collected. All of this really means little if the data collectors / controllers are not accountable. And this is why the enforceability of the DPA 2020 must be grounded in robust regulations when they're promulgated. And us as data subjects, irrespective of your being an individual or an organization, must ensure and insist upon it that the principles of data privacy are not only adhered to, but are done so, but the adherence is done in a manner that is fair, transparent, and lawful. I am watching the clock as I speak and realize I've just gone through the privacy issues and we're way down the road. So moderator, how are we for time?
We are not too bad. We did start about half an hour ago, about 1:15, so we're about half an hour in the official presentation.
Okay, so I will run through the security aspect of it. Then the fact of the matter is that the security conversation is a lot more mature than the privacy conversation. And so when we think about securing that data, so we've talked about the right of the data subject as far as the privacy of it is concerned. Now we're talking about the responsibility of the data collector or controller from a security standpoint. And sometimes this extends in a sort of shared responsibility to the data subject themselves. So we're saying that when we think about a general approach to data security, we have to conduct the necessary risk assessments. And we have to look at what data needs to be protected. We have to look at whose data it is, how sensitive the data is, what are the likely threats and vulnerability relating to the data. We have to evaluate the impact on the data subject should the data become compromised. And this is different for different persons, for different institutions. So your medical data being compromised is different than your financial data, than your personally identifiable data. But all of them have consequences. We must develop a data security plan that includes the implementation of security safeguards and user training for the persons who are handling the data. It is not enough, for example, to take the clerk from the reception and use them as data entry specialists and expect that they will almost magically adhere to the rules governing the data collection and storage and/or access and use. We must ensure that the persons who are employed for a particular function are trained and/or certified to do that. To this end, we must start to mature the relationship between academia and corporations to ensure that the people being pushed out of universities and other training institutions are the ones that can be taken up by the corporation and other employers. We must monitor the use and effectiveness of whatever safeguards we put in place, because oftentimes we focus on the technology and the security plan, but not the data we're seeking to secure. And so even though we might have a very good security setup, it really does not meet the threshold for protecting the data we're collecting. And so this sort of conversation is not one that happens in the server room, but must also take place in the boardroom. We must prepare an incident response plan before we need the incident response plan. So if we think about ransomware and the impact it has had, you can't be negotiating whether you pay the ransom or not, when your data is encrypted. You ought not to be doing that. You should have a plan as to what you're going to do before the ransomware hits. And like everything else, there is a cycle. And the adjustments must be iterative, it must be agile, and it must be done in response to perceived or identified gaps in how it is implemented. So if we were to progress the security plan a little further, then we have to look at some of the technical components. And here we're talking about your networks, we're talking about your devices, we're talking about your infrastructure. There has to be that continuous update of your outdated software or your, I can't say obsolete, or your old equipment. But you must be providing the best environment within which to store the data you've collected. And so this becomes critical when we talk about identity management. When we look at the fact that a lot of the workforce is now remote, we must ensure that the access management is also something that is tightly controlled, and the administrative and technical framework within which they operate is critical. Let us talk a bit about your devices, because oftentimes a lot of the challenges we have with the privacy of our data comes from the fact that our own devices that we use is what has led to the compromise. So let us take online banking, for example. When we look at it from the end user standpoint, the device they're using could be the point of compromise. But from the banking aspect of it, there is also the fact that there needs to be that secure connection that ensures the confidentiality and integrity of the data. We saw recently where there was a new compromise to some ATMs here in Jamaica. Usually we go in and we look for skimmers and we look for card readers. But these persons, they actually opened the physical ATM box and attached a device behind the data capture screens. Now, you might go in and you look at it and you say, okay, I don't see a skimmer, I don't see a card reader. This receptacle for my card does not look disturbed. Whereas behind the data collection screen, there is a data capture device or devices. And so, again, it comes back to that level of security that the institutions now must become transparent in disclosing this sort of thing. We have a difficulty when we talk about brand and image and reputation. But I want to submit to this audience and to anybody else who is listening that in cybersecurity, transparency and voluntary disclosure works better than obscurity and unwillingness to take responsibility. So when we look at security and privacy, we now must make a decision within ourselves. Is this really a dilemma, or is it a necessary confluence of concepts that the individual or the data subject, whether individual or corporation, must resolve with the data collector/controller in an effort to ensure that we have resilience within the data security, data privacy conversation. Ladies and gentlemen, I could go on for the entire day, but I know Mr. Hewitt would not permit. And so I would like to turn the floor over to you now to take your questions or concerns as it relates to your view of both sides of the conversation, because it's really that they're both sides of the same coin. We're talking about the security of our personally identifiable data. Thank you very much.
Thank you to our Colonel Sterling. As he said, the floor is open to share your concerns or ask any questions of him. Patrick, I see your mic open. Is there something that you want to say? All right, I can go first. What is a reasonable length of time after I have a concluded business with, say, a bank, that they would need to keep my personal information? Because I know I have bank accounts from years ago that I probably have not been to, but if I ask, I know they can provide me at least information up until that point in time. How long is reasonable there? Or at least what does the law say about it?
So the law does not speak to any specific period of time, and certainly muted.
Hey, Colonel Sterling, you're muted. You could just quickly unmute. Yes, that's good.
My apologies. So what I was saying is there is no specific time frame within the DPA for the shelf life of that data. And even when you look at the preservation of evidentiary data within the Cybercrimes Act of 2015, it really is dependent on the statute of limitations of other things. One of the arguments made by the collectors of this data is that it is costly to maintain. And so what we've had is suggestions as to how this can be done, whether it is by hashing or it is by ensuring that you take the pertinent snippet of data and preserve that as opposed to the entire data set. These are conversations that are now being looked at. However, if you use the example you used in asking your question about the financial institution, unless you're maintaining a relationship with the institution that includes the use of all the data they collected for a particular facility. So if we open an account, it's different from taking out a mortgage, for example. And the data required to open the account ought to provide a significant subset of what is required to take out the mortgage. Once the mortgage facility is done, that additional data set that facilitated the mortgage should be erased or anonymized because it is not pertinent to your maintaining an account. Now, the question is, if you have opened the account and you've left it dormant, you're really not saying to the bank that you're severing ties. You've just been lax in your obligation to maintain your account. So it really comes down to the individual situation. However, what we have seen in terms of the recommendations for preserving data is 7 years.
Okay, thank you. And I assume that the onus is on the ones who gave that bit of data to the various institutions to go back and check if they have anonymized or removed the data from their storage platforms? Is that something that we should do?
It is something you should do, but it is a shared responsibility. So the law provides for you to ask whether or not it has been done, but it also requires of the controller/collector to do it once it is no longer required.
Okay, sounds reasonable. Sounds reasonable.
So if the controller doesn't do it and you never check, it's really neither here nor there that it still exists, because
right.
they could always claim that, well, you know, this one just slipped through the crack. But we have that right, and we should exercise it to ensure that if we're done, we exercise the right to be forgotten from that database, erased from that database.
Fair enough. There is a running joke in the social space that when opening bank accounts, the various financial institutions would like your blood type, left lung, heart, liver, and kidney. How can we confirm the validity of the need of all the data that is required to open accounts in these various financial institutions locally? Because it seems different in various institutions. So is there anywhere you can go to certify if the information being requested is a valid need to whomever these banking institutions report to? And I presume that overarching institution is BOJ?
Yes, and that really is a short answer. All the legal requirements for data collection, for source of funds verification, for place of residence verification are in the BOJ regulations. And if the group will permit me, I'll share with you a very humorous story of mine. So I approached one financial institution and I wanted to make an investment. And they asked me for 6 months of proof of earnings. And I found it a bit onerous. So I went to the BOJ site. I found the regulations they quoted when I inquired why they required this. It did not say that. And so when I quoted the sections and subsections to them, the response was, well, this is our internal requirement. And so I said, well, can I speak to somebody more senior to you in the organization? And that person came on and decided that, well, this was the company's response to the BOJ's requirement so that they would never be in breach. And I'm saying, I can probably understand if and this was an institution that I was doing business with for some years. I said, I can probably understand if I was a new member from somewhere you don't know, but I find it onerous and I will not. And when I flatly refused, no less than a VP of the organization came and sought to pacify the situation. However, they wouldn't budge and neither would I. So the investment didn't take place. Now, the average Jamaican would not. They would just simply go download their statements and provide it. But I do not operate like that. Now, it takes time. It sometimes is very fractious. And oftentimes we're so concerned with the image that we will be seen to be contrary that we give up our rights. But as data becomes the gold or the platinum in this fourth information revolution, we, the data subjects, must ensure that our data, the minimal amount to do what we're doing is collected. The storage, processing, and transmission of it is adhering to the legal and other standards that it should, and that when we're done, were forgotten.
Fair enough. Hello?
Theo?
Yes, yes.
I was asking,
Go ahead, James.
yes, I was asking, now that we're in the age of the Pandora Papers, what does that really mean? I mean, what really happened there? I just want a Jamaican insight into that.
Okay, so the International Consortium of Investigative Journalists recently published about 12 million documents, which really sort of outlines the shady dealings of important figures, current or former heads of state, billionaires, and other significant figures. Now, if you think back to a couple of years ago, you had the Panama Papers, which were leaked from a law firm in Panama, which showed the same thing. But what we have seen here is a bit more than just documents being leaked. It's really documents that have been investigated, verified, and the claims substantiated that have really been put out there for public consumption. Now, probably the name Pandora was chosen because most of the persons so named, their countries, whether they're current or former serving, are in some of the blocks where corruption of public officials is a significant challenge. And it not only shows how the monies from these countries are being spent, but the fact that these leaders are actually hiding it, how they're spending the money. And some are doing it just simply to avoid paying taxes, which would go back into the coffers to help them run the countries. It also shows a bit of hypocrisy. If I may quote a leading journalist locally, which is that some of the countries that love to talk about blacklisting offshore tax havens are actually listed as benefiting from these shady investments. And so what it means is that as we put our information out there, as we do transactions, as we do business generally, a lot of it is residual on the internet. It means that if you have the resources and the time to look deep enough, it can be found. And what we're seeing from the ICIJ is that they're willing not just to find it, but once it's verified, to publish it. And so the takeaway for cybersecurity professionals within corporations is to ensure that that data that you think you've securely siphoned or put away or locked up is actually secure. And so it means that the different ways the investigative journalists have used to gain access to these documents may be teaching points for how you can further harden your network in terms of preserving the information kept therein.
Okay, sir.
Okay, Gio, can I go now?
Go ahead, Patrick.
All right, Lieutenant Colonel, I think your portfolio or the portfolio of the government regarding this whole topic here is huge. My comment has to do with the administrative side on the MDAs in particular, but naturally also in in the wider Jamaican environment. I think that the persons who use all of the various tools and are subject to the policies that are implemented need to be aware that every and anything that they input can be seen and recorded and utilized. As you alluded, there are apps where the information that you have input can be, saved and stored, and we've all experienced scamming. I think everybody has, some to a much greater extent. And I've seen where NCB has actually locked down the use of their card unless you do a direct transfer because of it. So the comment that I wanted to share was that I think the government should ensure that policy that is enforced on the administrators of all the various tools that persons within the environments, that the MDAs are protected to the fullest extent, but it comes from a government policy that says, for instance, that the password that you input cannot be seen by the and stored by the administrator, because it's so easy to do, and then you're not even aware that your own passwords are being stored. And I'm not talking the Google app, which gives you the opportunity to store or not store those passwords. So I'm saying from the apps that are created internally and other administrative procedures, it needs to be very important that these security provisions are enforced by a widespread government policy. I guess eGov, I'm not quite sure if MSTEM eGov would be a joint partnership in this.
Right, so thank you for that, Patrick. What I can say is that there is a policy currently under review, and that policy will really seek to set the framework for the responsible use of government ICT resources. And within that, coupled with the regulatory and enforcement capabilities of the ICT authority through the Office of the Information Commissioner, really ought to set the stage for the beginning of enforcing some of the provisions under that policy. Yes. It also, though, requires of heads of entities, whether you be a permanent secretary in a ministry or a division head in the ministry or an agency head, to ensure that you understand what it is that your information resources are and how you can best protect these, and where your staff need to be upskilled, retrained, or replaced, then that takes place. But it also requires that you have a finger on that pulse, and you must give particular attention to the training, the compliance efforts, and when your IT staff bring certain things to your attention, it ought not to just be swatted back down to them and say, look, go fix it. But you should try, as the the management cohort, to understand what are the implications and what are the possible solutions, and then work to fix it. So we have to take a different approach to ensure that the shift in the paradigm is irreversible, because where we have gone as a consequence of the pandemic and the driving force of the fourth industrial information revolution is not reversible. We're not going back to where we were 2018, 2019. And if we do not really start as the management cohort, taking those ICT concerns out of the server room and into the boardroom, we're going to have a significant challenge.
Yes, and until policy comes, but yes, fully understood and agreed. Thank you, sir.
You're welcome.
Any other questions from our participants? No? All right. So I would like to say thank you to Colonel Sterling for availing himself once more again. A very informative session indeed. Hello.
Hello. I'm sorry. Good afternoon. I'm really sorry. I was trying to get in a question, but I had some technical difficulties unmuting my
That's
line.
fine. That's fine. You can go ahead.
Thank you very much. And it was a wonderful presentation. My question regards data retention policies for schools. I'm not certain if the cybersecurity policy considers these scenarios where essentially a school collects information, personally identified information of students, parents, and so on. But it's really, you could kind of say that it's at the behest of the Ministry of Education as well. They are the ones who primarily will utilize this information for all sorts of stuff. So is there currently, or would there be recommended to have a centralized policy at the ministry level, or leave it to the individual schools to craft policies?
So I don't see individual institutions being allowed to craft data retention policies. I can see the Ministry of Education actually taking this task and owning it and ensuring that school administrators enforce it. Because what it really means is that as you look at the different cohorts, your information at basic level ought to be able to follow you through to tertiary. And thereafter, it really is a matter of just having the minimal information required to ensure that your transcripts, etc., can be unique records that are accessible by you as and when you need it. But some of the other bits and pieces really ought to be erased as you progress through the school system. And so to leave that to individual schools would lend itself to significant challenges in terms of management by the ministry based on what each institution retains, collects, and how they use it. Whereas a centralized policy would set those parameters out very clearly, and then it's a matter of enforcement.
Thank you. And one other question: would under the data, the Cybercrime Act or data policies, would a school be liable if there was, say, a data breach?
A data breach where? At the school?
Well, say at the school level, they have information. So, you know, some schools might have a ad hoc database management system. If there was, for example, a breach of that information made public under this act, would the school be liable? Would the ministry be liable? Where liability would lie?
The liability would lie really with the school administrators and the ministry itself, because both the ministry and the school administration would be seen as data controllers, data processors. And as such, they had a duty to ensure that that data collected, stored, transmitted was done in a secure manner. And for it to be breached was either a failing, if it was negligence, or some other situation if it was malicious. Now, when you look at simple breaches like persons hacking into systems to change grades and all of that, then it comes down to the system administrator at that institution ensuring that those grades that are stored locally are stored on secure devices or in a secure manner, as opposed to grades that may have been recorded and synchronized or transferred back to a central location. And so the manner in which any centralized or comprehensive data retention policies implemented across a ministry is going to be something that holds the ministry, vice GOJ, initially liable, but the administrators of that particular entity are also individually and collectively responsible.
All right, thank you very much, sir.
You're welcome.
So I presume that is it. So let me just ask one more time, is there anybody with any additional comments or questions? All right. So let me say again, thank you to Colonel Sterling for availing himself to deliver an informative presentation. And I hope that somebody learned something. Well, I know somebody learned something based on the questions that were being asked. Do have yourselves a wonderful rest of day. Be safe, and we will see you again tomorrow. Thanks again, guys.